तमाम का शुक्रिया अदा करता हूं कि जिस तरह की राजनीति आज भाजपा इस मुल्क के अंदर कर रही है, नफरत पैदा कर रही है, भाइयों के अंदर झगड़े कराने की कोशिश कर रही है। और ये जो बिल अमेंडमेंट लेकर आए थे, इसका मकसद भी यही था कि वक्फ बाय यूजर जो जमीनें हैं, हर गांव में, हर जगह में, मस्जिदों में नमाजें रोकी जाएं, कब्रिस्तानों में दफीने रोके जाएं और इसमें आपस में हिंदू भाई मुसलमान भाई धर्म की बुनियाद पर झगड़ा करें।
And now we have my colleague Brijesh Pandey joining us here in the studio. We also have Sanjay Chadha, Advocate, Supreme Court of India, and Ashish Pandey, Advocate at the Supreme Court, joining us on this broadcast. Thank you all of you for taking time out to be with us here on Newsline. Brijesh, let me begin by asking you a simple question. It is that, a small difference between a stay on the act or the bill and a hold. Because even before a stay could come, there was a request that there was an offer to hold it.
Well, I think, if there was an interim stay per se, it would have been a more embarrassing by the government. And the government also felt, what was in the mind of this Chief Justice of India.
Right.
And as Mr. Chadha said, that the vibes of the Supreme Court were very, very clear to the government. And that is the reason why even before the Chief Justice could say something or decide on granting interim stay or something to the effect.
Right.
He said that the government itself promises that, for the next, till the next date of hearing, the government is not going to enact key provisions, and there's going to be no alteration as far as whether it's waqf by land or waqf by deed, or appointing non-Muslim members as ex officio members in the board, or many other provisions. So basically the stay is there. The government has basically assured the court that we are not going to move forward till the next date of hearing. So it's going to be very interesting to see what is the response of the government as far as to buttress home their point about why there should be no ban, and this bill, the petitions filed by they should be dismissed, and the other side would also file the counter rejoinder to why they feel that that the arguments put forth by the government does not stand bottom.
Right. I think it was the Solicitor General Tushar Mehta who called it harsh. Sanjay Chadha, do you think this was a bit of a harsh move by the Supreme Court of India?
No. This is not the harsh move. This is, as my brother has very rightly said, it is nothing but a polite way of, politely the government has accepted the stay. Otherwise, it would have been a very harsher step if, the government would not have taken it in that spirit. And that's how Tushar Mehta has said in the court, and said that you don't know, to the court, he has said that you don't know what will be the repercussion if the stay is granted. So, on the other hand, I think this is how politely the stay has been accepted by the court, by the number one. And this is a very common practice. It is akin to stay. I'm telling you, there's no difference. It is akin to stay. Now the government will have to think 10 times to take any step. And so there is no question of taking any step in accordance with the new act. That is very clear. Number two, now, as I said earlier also, 5 petitions have been chosen. Out of those 73, bunch of those 73 petitions, 5 petitions are chosen, in which the government will file the reply. Even the state governments where they are party, they will also file the reply. And these 5 petitioners, the option is given to all the petitioners to select these 5 petitions. These 5 petitions will file the reply to the reply of the government, and then accordingly thereafter the 1, 2, 3, 4, I don't know how many dates will be there. The best part would be that it is the government has also proposed that it should be a day-to-day hearing. So this stay, the statement of the government is recorded that they will not act upon it. Especially 3 important provisions. One, waqf by where registered and notified properties are there. They are already registered and notified. There will be no action. No new appointment, whether in the central Waqf Board or at the state level. No new appointment will be given. This is a specific statement given by the legal officer of the government. So I don't think there is it is anyway less than or less than any stay. It is akin to a stay, I feel so.
Okay, akin to a stay, nothing less than a stay. Ashish Pandey, what about those who say, the judiciary is probably, overstepping its own reach?
No, I wouldn't buy that argument,
Okay.
especially in this case. You see, there were certain infirmities, please understand. The line of argument which one side is taking, the burden of proof is on someone whose land has been claimed as a land. This is one of the argument why this amendment has been brought. And when we say, when the inquiry is pending on the collector's side, and during the pendency of the inquiry, the property will be denotified as a work property, then both the line of arguments are contradictory. You cannot know both the lines simultaneously. So there were certain infirmities prima facie. So the court didn't have any other option but to politely say that please don't act on those lines, file reply, and then we will decide. Otherwise, we will issue a stay order, which could have been politically embarrassing for the government. So what we see that obviously there are certain provisions, like I said, that being a lawyer, I welcome when there is a opportunity is given to the aggrieved party to approach to the court. That is a welcome step. And then this line of argument that if the work by user is completely derecognized and the properties are denotified, then what will happen with the properties like which are hundreds of years old? So how to reconcile these infirmities? So it will be very interesting to see how the developments will take place in the court. But what happened in the court was very much logical today.
What happened in the court was very much logical. We will take a very short breather here at the stage. We'll be back with lots more on the side. Keep it with News 9.
This is India's #1 news network, and you're watching News 9, English news as it should be. Coffee?
I am Idea Cool. ये एयर कंडीशनर नहीं, AI कंडीशनर है.
Smash your way to glory at the News 9 Corporate Badminton Championship. Get ready for the ultimate badminton showdown. News 9 presents the biggest corporate championship, a battle of skill, speed and supremacy. Cash prize of 6 lakh rupees across categories. Venue, Pulela Gopichand Badminton Academy, Hyderabad. Dates, May 9th to May 11th. A chance to showcase your talent and make a mark. The court is set. Are you ready? Register now.
This is India's #1 network, and you're watching News 9, English news as it should be.
You are watching News 9. I'm Krishna Kumar, and the big story that we're tracking is at the Supreme Court of India, which, while resuming its hearing on petitions filed against the Waqf law, in a sense put a hold on the implementation of the Waqf Amendment Act before a possible interim stay could be issued by the court. The government choosing and offering and telling the court that it will not implement the provisions of the Waqf Amendment Act, especially the key provisions including the inclusion of non-Muslims in the Central Waqf Council and Waqf Boards, and provisions on denotifying properties declared as Waqf by courts. All of this, the government said, the centre said, will not be acted upon for the time being. The court giving the centre 7 days time to file a preliminary reply. We have my colleague Brijesh Pandey with us on the broadcast, joining us here from the studios. We also have Mr. Sanjay Chadha, advocate of the Supreme Court of India, and Ashish Pandey, advocate of the Supreme Court of India, with us on the broadcast. Brijesh, let me bring this back. For the government, this was, a quote-unquote, a face-saving act, but clock is still ticking. for the central government?
Well, I think, the government realized the mood of the judge very quickly, and I think yesterday, if you look at the fact that when Solicitor General Tushar Mehta said that if you don't get a stay or something, in fact, we can start from tomorrow, like changing the or going ahead with the denotification and letting the Key Act proviso being enacted by the state and the centre. And today, when the Chief Justice asked him the same question, he had a very different line. Though he said that that I hope you are aware of the kind of action that is being taken, but he read the mood of the judge very correctly, and that is the reason why he immediately assured the court. And being as a law officer, his word meant means a lot as far as putting the version of the government is concerned. He assured the government that there's going to be no denotification. He assured the government that there's going to be no appointment of non-Muslim members in the board, central or state. And he also, basically, primarily, he said that there's going to be no denotification, and the entire provisos of the act will be implemented once once they have filed the reply and also a 5-day rejoinder by the other party. It is a face-saving gesture, I would say, but it could have been, if the. But I agree with Mr. Chadha when he says that it's a normal routine legal practice. When you realize the judge is not in a mood to grant you any kind of relief, you immediately take the side B and say that I assure you that we are not going to act till then. But yeah, it's a bit of a setback as far as the central government is concerned, and that is the reason why you heard Mr. Amanatullah Khan and also Asaduddin Owaisi, they're very happy. They're saying that they'll fight the case out, till the end. But if you look at the way, the Chief Justice has said, he has not, dismissed the entire act. He said that there are certain provisions in the act which are very good, but there are certain provisions which need to be relooked into. Right. So I don't see a complete complete stay on the entire act, but yes, the government may have to modify certain acts.
Sanjay Chadha, the question I have to ask you is that you call it routine, but Mr. Tushar Mehta says it's rare that that a court takes action like this. It's not every single day that you see a bill that has been passed as an act with the requisite numbers in the Parliament finding a hurdle at the Supreme Court of India.
There are two limbs of your question. One, routine. I said that when a lawyer is, an order is going to be passed against him, he will say, please, we accept this much. So, face saving. That is what I was saying. And as far as this practice is concerned, yes, Parliament has passed the law. Parliament has given full consent. But we are governed by, not only by Parliament, we are governed by rule of law. We are governed by checks and balances. It is not, if at all a law passed by the Parliament is contradictory to the, it has provisions which are opposite to the basic structure of the Constitution, such law will be thrown away. Such provisions will be ultra vires to the Constitution. This is a very settled provision, settled principle. Keshwanandan Bharti, 13 judges. Now nobody can change that. We have a very established law that we are governed by checks and balances. So here, if a Parliament passes a law, that law is somewhere contradicting the basic structure of the Constitution, like violating the fundamental right, and so on and so forth. Those things are there, then what will happen? The Supreme Court has a power to struck down those provisions, and Supreme Court has a power to remove those provisions. If you want, I can give you an example also. The example of this, the cyber law, where section 66A was removed by the Supreme Court. That this is to the Constitution, more specific, Article 19(1)A. 19(1)A very specifically gives you right to, freedom of speech and expression. And that section 66A used to violate the freedom. So the court struck down such provision. Very much within the ambit of the power, and this has happened not once, several occasions we have seen the Supreme Court striking down provisions of law which are ultra vires to the Constitution.
Not the first time, will not be the last time, isn't it, Mr. Ashish Pandey? In that sense, the court is essentially doing its job. Now it's all up to the centre, and more importantly, 7 days is all that the centre has at this stage. What kind of a response do you think will be needed? Because the court, the top court itself said that there are some positive things about this act, We did not say everything was wrong. We just said certain provisions of the act is what we have that needs to be re-looked into, if I may.
Yes, absolutely right. I mean, it's very difficult to say what the center is going to file as interim reply within 7 days. But you see, the general principle is when a law is passed by the Parliament of India, then it is a presumption that the law is constitutionally valid until unless it is shown in the court that it's ultra-virus to certain provisions of the Constitution. Now, the observation which is flowing from the Honorable Bench is that there are certain infirmities. But it would be interesting, as a lawyer, it would be interesting for me to observe whether these infirmities are administrative infirmities or the constitutional infirmities. That is, there has been no obiter dicta to that effect which has flown from the bench. So we'll wait for the center's reply. I presume that it won't be, the reply won't be much on merits, but what we are hearing that because the center has made an argument before the court, that they have received so many petitions and references and case instances where land grabbing has been done, and aggrieved parties have sent the representation to the government. Maybe those representations, maybe in tabular form, may be presented to the honorable court, and then at the end of the day, court will see. I mean, if these provisions, certain provisions which the court finds that there are certain infirmities, will be there or not, or whether there will be a stay on those provisions after 7 days.
All right, Ashish Pandey and Sanjay Chadha, stay with us. We are taking another short breather here on the show. We'll be back with lots more on the other side. Keep it with News 9.
This is India's #1 news network, and you're watching News 9. English news.
Bye, please.
आई एम माय डियर कुल। ये एयर कंडीशनर नहीं, AI कंडीशनर है।
Smash your way to glory at the News 9 Corporate Badminton Championship. Get ready for the ultimate badminton showdown. News 9 presents the biggest corporate championship, a battle of skill, speed and supremacy. Cash prize of 6 lakh rupees across categories. Venue, Pulela Gopichand Badminton Academy, Hyderabad. Dates, May 9th to May 11th. A chance to showcase your talent and make a mark. The court is set. Are you ready? Register now.
This is India's #1 news network, and you're watching News 9. English news as it should be.
Hello and welcome. You are watching News 9. I'm Krishna Kumar. Time now to cut across live to West Bengal's Chief Minister Mamata Banerjee, who is speaking on the teacher recruitment scam of the state. Let's listen in.
ত্রিপুরা যেতে বলুন, আসামে যেতে বলুন। ত্রিপুরা তো আমাদের হাতে নেই, আসাম তো আমাদের হাতে নেই, মণিপুর তো আমাদের হাতে নেই, আর বর্ডারও আমাদের হাতে নেই। প্লিজ রিমেম্বার, আগে বর্ডারের 5 কিলোমিটার পর্যন্ত বিএসএফ এর আন্ডারে ছিল। প্রেজেন্ট হোম মিনিস্টার আইন করে 50 কিলোমিটার করে দিয়েছে। অর্থাৎ আমাদের মানুষ থাকলেও আমরা তাদের সাথে গিয়ে দেখা করতে পারি না, তারা আমাদের সাথে যোগাযোগ করতে পারে না। রাজ্য প্রশাসনের হাত থেকে কেড়ে নেওয়া হয়েছে 50 কিলোমিটার। কেন এটা হবে? এটা তো আমারও যুক্তি। প্রথম দিন থেকে আমরা করেছি এবং করে যাব। আপনারা আমাকে বলুন, এসব কোয়েশ্চেন জিজ্ঞেস করবার আগে কখনো ভেবে দেখেছেন? আর্লিয়ার দেয়ার ওয়াজ এ সিস্টেম, বাইরে থেকে যে কেউ আসলে দেয়ার ওয়াজ এ সিস্টেম, আমাদের ওয়েস্ট বেঙ্গল পুলিশের লোক থাকতো অ্যান্ড তারা একটা ডেটা রাখতো, কারা আসছে, কোথা থেকে কিভাবে আসছে, কোন কাজে আসছে। এই হোম মিনিস্টার আসার পর দে উইথড্র দ্যাট, আমাদের অফিসারদের অ্যালাউ করে না টু কিপ দ্য ডেটা উইথ দেম টু ফাইন্ড আউট দ্য ডিটেলস অ্যাবাউট দ্য আউটসাইডার্স. Outsiders, I am not blaming all, but few sections who have some critical area, there our police should have taken the special care. But now we cannot do it because Home Ministry already withdrawn the state government data sharing process since 3-4 years. And number two, even railway also, regular যাতায়াত করছেন, বর্ডার দিয়ে কে যাতায়াত করছেন তার জন্য আরপিএফ আছে, জিআরপিএফ আছে, ওদের নিজস্ব প্রোটেকশন ফোর্স আছে. 3 হচ্ছে বিএসএফ বর্ডার দেখে, সিআইএসএফ কোল দেখে. তো এর মধ্যে আমাদের জড়াচ্ছেন কেন? গরু দেখে বিএসএফ, কয়লা দেখে সিআইএসএফ.